Well, this is embarrassing. I thought I was recording, but apparently I'm live. So you're now live with me. So I apologize. Anyway, I hope you're all well. I mean, it's been a while since I've done this. And we had a storm the other day and it blew up my other screen. So I'm on one screen. So this is all going to be fun because I have no idea how this is going to work. But I got notified that there were some new documents in the Bruz and Google case. So let's have a look here. So we have got, oops, I've got down here, look, on the 28th of January, on the 28th of January 2022 at 12 o'clock, there was an administrative listing with Justice Rares and it was adjourned pre-hearing and there are orders that were done. So let's have a look at those orders. I hope this is flicking and I hope this is working because I have no idea how this works. Alrighty. I hope you can see that now. Let's have a look. Can you? No, that didn't change. Okay, I'm going to have to do this the long way. All right, I have to get a second screen up. All right, here we go. So we've got orders from the federal court. Now they're consent orders, so which means that it's just been signed off really by the court because they've agreed to it. So the respondent has leave to file an amended defence substantially in the form Annex 2. Oh, hello everybody. I've just seen the the chat. Yeah, so the respondent has leave to file an amended defence substantially in the form annexed in these orders, marked A within 3 business days of the date of this order, and the respondent pays the applicant's costs thrown away by reason of the amendment to the defence, but otherwise court costs of the interlocutory application filed on the 25th of January 2021 be the parties' costs to the courts. Now, we have to take a few steps back here because if you remember, John Barilaro, Bruz, our Bruz man, he sued Friendlyjordies and Google for defamation. He settled with Friendlyjordies and they came to a settlement, but he kept the case with Google. So here is our problem. Well, that's not really a problem. He's kept his case with Google. So let's have a look at what's happening with Google. We actually have the orders here. We've got the amended defence here. All right, so as you can see, there's when they amend it, it's all crossed out. Yes, way he sued Google. Yes, Alberta and Stella, he is taking on Google. He is. I swear to you, I promise you, he is. He's suing Google. So as you can see, it says second respondents. So they've crossed out the word second. So it's respondents amended defence to statement of claim because when they did their initial response, they were the second defendant. He was a politician. I know, Alberta. So when he did, they did this initially as the second respondent. They were actually supporting Friendlyjordies or Jordan Shanks, Macarena, who was the original respondent. But now that that has settled, they have to actually now file a defence where they're the respondent. And instead of supporting Friendlyjordies or Jordan Shanks, they actually have to bring their own claim. So you can see that Jordan Shanks has been crossed out here. I'll just make it a little bit bigger for you. So Jordan Shanks has been crossed out, and another, well, they were the other. So it was applicant John Barilaro, respondents was Jordan Shanks and another. That's been crossed out, and it's Google LLC. So the matter is now between John Barilaro and Google. Oh, here we go. Oh. So it says the respondent relies upon the following facts and assertions in answer to the statement of claim filed by the applicant on the 27th of May, 2021. So the respondent admits the allegations in paragraph 1 and 2 of the statement of claim. Well, remember the Fox, Bruz has now quit politics. He's now not a politician. So I'd like to know who's paying his solicitor's bill, because his barrister's just got to pay got costs of $400,000 for one of her cases, where she's got to pay costs anyway. So the respondent admits the allegations in paragraphs 1 and 2 of the statement of claim. In response to paragraph 3 of the statement of claim, the respondent admits the allegations in subparagraphs A and B and denies the allegations in subparagraph C. In response to paragraphs 4 to 8 of the statement of claim, the respondent admits that on or from 30th of December 2020 until the 5th of November 2021, it published the first matter complained of. AA notes the admission made by the applicant in open court on the 26th of November 2021 to the effect that the edited version of the first matter complained of, published since the 5th of November 2021, is a different publication, and that the applicant does not make a claim in relation to the publication of that video. That's important to note. There was a settlement that came, and on the 5th of November, there was an amendment made to the video, and they don't have a problem with that video. So they also admit on the 22nd December 2020, it received a letter from the applicant's solicitor about the first matter complained of. I don't know. All right. The Porter Blind Trust, yeah, probably. So it admits that he had not removed the first matter complained of and continues to publish it. And it relies upon the particulars below in relation to the extent of the publication, and otherwise denies the allegations contained of in paragraph 4 to 8 of the statement of claim. Particulars required by clause 4.7 of the defamation practice note, see respondent's statement indicating extent for publication on the 17th of November 2021. So as I said, they've had to make some changes. So as to the paragraph 9 of the statement of claim, the respondent admits the first matter complained of was of and concerning the applicant, denies that the first matter complained of in its natural and ordinary meaning carried any of the imputations in 9A and 9E inclusive, admits that if found to be conveyed, each of the imputations to 9A to 9E inclusive are defamatory of the applicant, and otherwise denies the allegation in paragraph 9. In response to 10 to 14 of the statement of claim, it's sort of the same thing, admits that on and from the 22nd of January 2021 until November 7, 2021, he published the second matter. And again, they've put in that note that admission made by the applicant that they don't have any problems with the amendments that were made. So they admit that they received a letter from the lawyers and relies upon the particulars in the extent. So, hello, boy. Okay, so then we've got, so this is much the same. See respondent's statement. So they admit the second matter was of the applicant. They deny. They admit if found to be true. Otherwise, they deny the allegations. It's just, they're just taking on all the, and again, he was happy with the The second, that he was happy with the, okay. So they deny the allegations in the statement, paragraph 17 and 18. In further answer to applicants' claim for agreed damages based upon publication of the edited version of the first matter complained of after the 5th of November 2021 and the edited version of the second matter complained of after the 7th of November 2021, which he has not particularised but was referred to by the applicant's senior counsel in open court on the 26th of November 2021, the respondent says, on May 27th, 2021, the applicant commits these proceedings, naming Jordan Shanks Markovina as the first respondent to the proceedings. By his originating application, sought relief against Jordan Shanks Markovina, including damages, aggravated damages, and an order permanently restraining Jordan Shanks Markovina from publishing the matters complained of. Now, let me just tell you, in my opinion, Jordan Shanks is much more of a journalist than another one that purports to be a journalist, by the way. Just saying. So the statement of claim included a claim for aggravated damages against Jordan Shanks Markovina on the basis that the first matter complained of contained inter alia John Barilaro, aka Greasy Ned Kelly. Referred to him as a Greasy Ned Kelly. Oh boy. Sorry, I shouldn't laugh. In about early November 2021, the applicant and Jordan Shanks Markovina agreed to resolve the proceedings between them on terms which included that Jordan Shanks Markovina would edit the first and second matters complained of, and there would be no payment of any damages or compensation to the applicant. Now, I always find it really interesting how he doesn't have to pay any compensation. The agreed edits included removal of some relief upon the applicant as giving rise to imputations in relation to his claim for aggravated damages, but not the matter in relation to see above. It is implicit in the agreement that first and foremost, the second matters complained of be edited, that they be published in edited form. By compromising his claim against Jordan Shanks Markovina without insisting on the removal of additional matters which the applicant asserts the aggravated damages, including the matter set out in C above, and or damages to compensate for those matters having been published by Jordan Shanks, the applicant impliedly consented to the publication of the edited material, edited version of the first matter complained of concerning the matter. That's a really good point, actually, that they've made, that they insisted on certain parts being edited, but they didn't actually insist on all the changes. And so some of the things that they've complained of, they can't now say are defamatory if they were happy with the changes made. It's just very interesting. All right. So it is implicit in this agreement that the first and second matters complained of be edited, that they be published in edited form. Oh, sorry, we did that, sorry. On the 5th of November 21, Jordan Shanks Markovina edited the first matter complained of in accordance with the agreement reached by the applicant. On the 7th of November 2021, Jordan Shanks Markovina edited the second matter complained of in accordance with the agreement reached with the applicant. In the circumstances set out above, the respondent's conduct in publishing the edited versions of the matters complained of after the 5th of November 2021 and the 7th of November 2021 was not unjustifiable, improper, or lacking bona fides. Okay. So now they're going to go through their defences and the Defamation Act. So this is their defences. So one of them is qualified privilege. And the common law in Section 30 of the Defamation Act So Google is public qualified privilege. Their second defence is the public interest defence. So that it was in the public interest that these matters be brought to light. The third is honest opinion, and honest opinion in relation to public interest matters. Now, don't forget that when Bruz resigned, he used the court case as a reason for the resignation. And then he settled with Friendlyjordies, and then he hasn't settled with Google. So here is this is the privilege, this is how they've come to qualified privilege. So during this time, at the Material Times, the applicant was the Deputy Premier of New South Wales, the Leader of the Nationals in New South Wales, a member of the Legislative Assembly of New South Wales as the member for Monaro. No, we're not paying for it now. He's a public citizen now. He doesn't get that privilege. That he was a Minister for Regional New South Wales Industry and Trade. And the first matter complained of in relation to the following subjects: the conduct of the applicant in conjunction with the positions referred to in paragraph 10, the New South Wales government, the politics in New South Wales, the Nationals, the actions of the applicant in connection with the 2019-2020 Black Summer bushfires, the 2019-2020 Black Summer bushfires, funding and resource cuts to New South Wales National Parks and Wildlife Service, water theft, the Murray-Darling Basin, the actions of the applicant in connection with the proposed Royal Commission into into water corruption, the allocation of government funds, and pork barrelling. They've not left anything out, and don't remember he called himself Pork Barilaro. Then we've got the matters: the Go New South Wales Equity Fund, Rock Partners, the government investment in Australia's Oyster Coast, questions and answers given by the applicant in New South Wales Parliament, the government's investment in a beef company, transparency of New South Wales government deals, the Pricing and Regulatory Tribunal, New South Wales Arts Grants Program, Kosciuszko National Park, a proposal to cut wild brumbies in Kosciuszko National Park, the applicant's alleged conflict of interest in relation to the Wild Horse Heritage Bill, regulation of businesses such as Airbnb and stays, the applicant's conflict of interest in relation to the Wild Horse Heritage Bill, the applicant's alleged conflict of interest in relation to the regulation of businesses such as Airbnb and stays, the applicant's ownership of a large estate, the applicant's compliance with lockdown laws in relation to COVID-19 pandemic. Wow, and that's why they're saying it's qualified privilege and public interest. The second matter complained of. So now we've got the second video. So that was just one video. Now we're on to the second video. Airbnb. Well, that's right. Remember, he owns an Airbnb. And we know that that's what the problem was. The second matter complained of in relation to the following subjects: the conduct of the applicant in connection with positions referred to in paragraph 10, the New South Wales government, politics in New South Wales, the Nationals, regional New South Wales, the regional town of Narrandera, the Nationals management of the regional town of Narrandera, the local council of Narrandera, the Environment Protection Agency, grant monies given to Narrandera, the use and misuse of grant monies given to Narrandera, sewage treatment, blue-green algae, the Murrumbidgee River, fish kills in the Murrumbidgee River, water management, the Narrandera to Tocumwal rail line, a feasibility statement into Narrandera and Tocumwal rail line, the availability of a report into feasibility study into the Narrandera to Tocumwal rail line, and accountability and transparency in relation to expenditure of the taxpayer money. I'll have to ask one of our, can't remember who. Yes, I'll have to find out whether that did happen, because it'd be interesting. So these are subs. They were first and subs. So for each of the first subject matters and second subject matters concern government and political matters that affect the people of New South Wales and Australia. And accordingly, each member of the Australian community has an interest in disseminating and receiving information, opinion, arguments on these topics. The respondents' conduct in publishing the matters complained of was reasonable in the circumstances. The respondent was aware at the time of publication that an implied freedom of political communication exists in Australia as an indispensable part of the system of representative and responsible government created by the Constitution. The matters complained of related to subjects, each of which concern government and political matters, and were matters of proper and legitimate public interest. Jordan Shanks Markovina is an Australian political commentator who has published content on YouTube channel with the account name Friendlyjordies since 2013. The Friendlyjordies account has over 500,000 subscribers, and Jordan Shanks Markovina regularly publishes political content to subscribers and viewers of the channel, including political opinions and interviews with politicians. The matters complained of appeared to have been scripted and produced with considerable technical skills and support, and appeared to have been the product of considerable research, included supporting and collaborative materials such as quotes from the applicant, photographs, images of tweets and articles from reputable and responsible media in Australia, appeared to include material which may reasonably be understood as an admission by the applicant, such as the quote attributed to the applicant at 642 of the first complained of. When we do, it's pork barreling. Well, my name is John Barilaro. You call me Pork Barilaro, and I have no apology, because at the end of the day, I will stand up and fight for our communities. There you go. That's his quote. He's call me Pork Barilaro. The matters complained of made serious allegations about the applicant, which directly concern performances by at public functions. So, as a senior politician in New South Wales, the respondent is an internet intermediary which, among other things, owns and provides for use by public YouTube, an online video sharing and media platform. It is the policy of the respondent in Australia that it encourages an aggrieved person to contact the uploader of the content alleged to be defamatory directly, including because the respondent is not in a position to adjudicate the truthfulness of the content. This is a reasonable position to take to ensure that free speech is adequately balanced with the right to reputation. On the 30th of November 20, the respondent received a complaint on behalf of an applicant about a video published by Jordan Shanks Markovina entitled I Called Barilaro, He Answered, which alleged the applicant had engaged in an extramarital affair. The I Called video describes the allegation as a nasty rumour, which, by the way, can we just preface, has since come to light that that allegation may in fact be true. So, anyway, on the 16th of December 2020, the respondent blocked the I Called video there was a reasonable course to take in circumstances where it was apparent on the face of the iCalled video that the allegation was based on rumour, and the allegation did not relate to the applicant's performance of public functions. On or about the 30th of November 2020, the respondent received a complaint on behalf of the applicant about a video published by Jordan Shanks Marcavina entitled The Italian Job, which alleged the applicant had been defamed by the video. On about the 16th of December 2020, the respondent advised that it was unable to determine the merits of the applicant's defamation claim in relation to the Italian Job video, and accordingly would not remove the video under the respondent's defamation policy. Well, the rumour is now, Bo, that there's it was one of his staffers, and there's a new Barilaro on their way. That's the rumour. Now, about the 16th of December 2020, yeah. I'm just flipping between tabs here. Yeah, on about the 30th of November 2020, the respondent received a complaint on behalf of the applicant about the matter complained of, which alleged that the applicant had been defamed by the video. On about the 16th of December 2020, the respondent advised it was unable to determine the merits of the applicant's defamation claim in relation to the first matter complained of, and accordingly would not remove the video under the respondent's defamation policy. On or about the 22nd of December 2020, the respondent received a letter from the applicant's solicitors which complained about, amongst other things, the first and second matters. I'm just going to close my door. Hold on. Hopefully that's better. And accordingly would not remove the video under the respondent's defamation policy. On the 22nd of December 2020, the respondent received a letter from the applicant's solicitors complained of, amongst other matters, the first and second matters complained of. The letter states the applicant's solicitors had sent a letter to Jordan Shanks and provided a copy of the letter. On the 24th of December 2020, respondents sent an email to the applicant's solicitor requesting additional information to assist the respondent to evaluate the request. On the 12th of January 2021, the applicant's solicitor sent further letter to the second respondent, or to the respondent. The letters of 22nd of December 2020 and the 12th of January 2021 both asserted that the imputations alleged to be conveyed, some of which are different to the imputations pleaded in the statement of claim, were false, although they did not provide any information in support of the assertion of falsity. In light of the matters set out in 14.3, 14.4, and 14.12 to 17 above, the respondent was unable to determine the merits of the applicant's defamation claim in relation to the matters complained of. In the circumstances set out above, and in particular in the circumstances where the matters complained of related to government and political matters, it was reasonable for the respondent to decline to remove the matters complained of until such time it was removed by Jordan Shanks Marcavina or adjudicated upon by a court. So now they're doing common law privilege. So they're talking about the fact that it was about New South Wales, that they were political matters that affected New South Wales and Australia. Implied freedom of political communication exists in Australia. That Jordan Shanks Marcavina is a political commentator that he publishes. And so they've just repeated that again. Oh, bye, Alberta. All right. So I just cannot believe, I still can't believe that he's still persisting with Google myself. Anyway, the matters complained of appeared to have been scripted and produced with technical skills, so they're just repeating that again. included support. And that was the thing. If you watch any of his videos, he does actually show, he backs everything up with receipts. So again, about performance of public staff. So that's essentially, they've just repeated the above. So statutory qualified privilege, again, they're repeating the same defence. And then the public interest repeats the particulars in 10 to 12. The respondent was aware at the time of publication that implied freedom of political communication. We've repeated that. And they've put in 3 times, they've put in this quote about pork barreling. Their policy, they've repeated the complaint, so everything's been repeated. And now, honest opinion. The first matter complained of was an expression of opinion of Jordan Sheets Markovina. The opinion was based on facts and matters stated and or referred to in the first matter complained of, set out in Schedule A in the defence. The facts and matters set out in Schedule A to this defence were proper material for reasons specified. The opinion related to the first matter subject and were subjects of proper and legitimate public interest. Short order says, I can't believe this is still going on. I can't either. I can't believe Bruz is still going after Google. So if, which is denied, the applicant suffered any damage as a result of the publication of the matters complained of and or the imputations pleaded in the statement of claim, then the respondent intends to rely upon the following facts and matters in mitigation of such damage. So they're saying, okay, well, let's just say the court finds in favour. This is what we want taken into consideration. Any damages or compensation payable to the applicant as a result of proceedings brought by the applicant for damages for defamation in relation to the publication of matter and having the same meaning or effect as the matters complained of, including any damages or compensation payable by Jordan Sheets Markovina. Well, he didn't have to pay any damages. The facts and terms of the settlement agreed between the applicant and Jordan Sheets. The editing of the first matter complained of on around the 5th of November. The editing of the second matter complained of around the 7th of November. The matters set out in paragraph 8A. The facts, matters and circumstances proven in evidence in support of the defences pleaded in this defence. The circumstances in which it is provided proved that the matters complained of were published. And this was stated and settled. So this is a certificate. So each lawyer has to start, the lawyer that writes it, he certifies to the court that in relation to the defence filed on behalf of the respondent, the factual legal material available to me, the present provides a proper basis for each allegation of pleading, each denial, and each non-admission. Okay, and then this is Schedule A, Respondent's Defence of Claim. So they've got here proper material, allegation 1. The applicant blamed the National Parks and Wildlife Service for the 2019-2020 bushfires, claiming they were ideologically opposed to hazard reductions paragraph. And it says the material is proper material by reason that is substantially true. Respondent relies upon the following facts in support of the substantial truth. During the 2019 to 2020 bushfire season, severe bushfire burnt through New South Wales and Australia, resulting in the death of 33 people, the death or displacement of nearly 3 million animals, the destruction of over 3,000 homes and tens of millions of hectares of land. On about the 22nd of January 2020, the applicant gave an interview to Andrew Cannell of Sky News, during which he stated the following in response to a question seeking his views about the Prime Minister wanting a national hazard reduction system and raising the possibility of states being named and shamed if they don't do hazard reduction. He welcomes a national system. He believes fuel loads on the forest floor are far too high. We have arbitrary targets, which are probably set up by our own agencies who are ideologically opposed to hazard reduction. During the interview referred to in the proceeding in particular, the applicant was asked whether he was saying that his own government agencies were responsible for not doing enough hazard reduction, to which he responded, "I've never minced my words. I've answered those questions in question time. I genuinely do believe we have agencies within government that over decades haven't actually honoured their commitment to fuel reduction because of ideologically positions, and especially national parks. We just lock them up. That's the Bob Carr legacy. Lock it up and let it burn." I think that culture has existed for a long time. During the interview, the applicant also stated, "My view has always been that agencies like national parks, who their sole purpose is conservation, ideologically don't like the concept of hazard reduction, but we give them the responsibility." So they're just talking about, this is the allegation, here's what they're relying upon. And again, they're saying that it's substantially true. So the applicant was involved in the decision to cut the funding to New South Wales parks by 27%. The number of rangers, New South Wales parks and wildlife have been cut by 100. And they're saying that it's substantially true. The respondent relies upon the following facts and about budget cuts. So essentially, I have to say, Google has come out fighting. And if we look at all of this stuff, and again, this material is proper material. It was published on the occasion of absolute privilege, namely proceedings in Parliament. And don't forget, the applicant responded, Helen Dalton of the Shooters and Fishers Party asked the applicant why he broke his promise about Royal Commission into water corruption, and the applicant responded, "Helen, you are a disgusting human." It's substantially true. It relies upon the facts. On the 4th of May 2020, Helen Dalton tweeted, "Can't believe John Barilaro would say something and then do the opposite. That's never happened before, has it?" Together with images of the applicant being the captions, "Tell the peoples of Menindee that we need a Royal Commission into the MDBP," then votes against it in Parliament along with his Liberal and National buddies. On the 4th of May 2020, the applicant tweeted a reply to Ms Dalton's tweet stating, "Helen, you are a disgusting human. All politics. Today it was a decision for my family." The applicant has called himself Port Barilaro. This is substantially true. On the 25th of May 2020, the applicant gave a press conference in Tamworth, during which he was asked about an arts grant given in coalition electorates. During the press conference, the applicant stated, "I have no problem and no apology to make in relation to fighting for our fair share of funding in the regions. On one side, you have the Labor Party accusing us of not spending the 30% of Restart or investing it into regions. When we do, it's pork barreling. Well, my name is John Barilaro. Call me Port Barilaro, and I have no apology because at the end of the day, I will stand and fight for our communities." On about August 28th, 2020, the applicant tweeted, "People call me Port Barilaro. Well, I wear that with a title. I wear the title with a badge of honour. My focus is getting a fair share for our regional communities." All right. So, the applicant was the spaghetti eating champion for 25 years. Apparently, it's substantially true. It says it relies upon the material from approximately 1988 to 2013. The applicant was the spaghetti eating champion at the annual Italian Community Day Festival. No way! Oh no! They have a warning to people: don't take on Google. Port barreling is giving government money for seats that don't need it. It's substantially true. Port barreling is the utilisation of government funds designed to support electors. So we've got some more here. Oh boy. And they've gone in and got financials and everything to show that it's all true. Again, the New South Wales asked the applicant multiple times whether he gave taxpayers' money to Coast. Now they're here, proceedings, naming proceedings in Parliament. It's absolute privilege. Yeah, I'm going to tell you, don't ever take on Google. Here's a transcript of the committee. To be honest, in my opinion, what a badge of honor, yeah, sport. You'd be proud of the title, spaghetti. And I must say, I do like my spaghetti too. I think received $10,000 political donation from Peter Cochrane, the owner of a horse tracking in the Snowy Mountains. Here it is. The applicant received a donation of $5,000 from Peter Cochrane and a further $5,000 from Cochrane Horse Tracks. He's a former member of Monaro. Oh, look. The applicant's estate is listed as a short-term rental on Airbnb. It's based substantially true. Respondent relies upon the applicant's estate is available for short-term rental on Airbnb and stays under the property name of Dungowan Estate. It did not conflict. It talks about the conflict of interest. That the applicant did not disclose his business use of the property until 2016 when questions were asked by the media. Oh, that's right. When he traveled to his holiday estate saying it was essential to feed the chickens and mow the lawn. So there you go. That is their defense. Well, he can't deny it. No, that's right. Friendlyjordies did stay there. So that is Google's amended defense at this point in time. So my point is going to be, don't take on Google, because they have listed every allegation and has said it's substantially true or partially. In my opinion, Bruz would have had more chance of winning if he'd taken on Shanks, because Shanks, only had limited money. Where Google, and don't forget, this could be a benchmark for defamation cases that people are going to try and sue Google for in the past. Yeah, I think it all comes down to, is Google responsible for what's on their platform? Now, they did say they did take down one video because it was based on something different. It was based on rumor, not fact. Or there was no they are Google. They are. I was going to say. So we go back to where are we? So we now go back to this. So as I said, there was administrative listing because Google had to change the defense because they weren't the second respondent anymore. They are the respondent. So we've got on the 9th of February, returns of subpoenas. And then we've got on the 21st of March is the hearing. And that's scheduled to go to the 1st of April. Bruz is a very brave man. He should just opt for the bonfire. I think he's hoping that a blind trust will come through for him like it did for Porter. I don't know what I don't know of any other explanation, because as I said, I wouldn't be taking on Google, but that's just me. Yeah, I mean, it could be, this could definitely be a test case. I don't know, yeah. Well, Bo, he does have the, well, actually, his ex-wife has actually got the property now, I believe. She kept the property. He got kicked out. He got kicked out. He just sold his city apartment, but I believe that he's got there's an extra mouth to feed coming, which means that what Friendlyjordies shared was not actually rumor, even though it was rumor. There was truth to it. It was a staffer. It's alleged it's a former staffer. But he blamed his quitting on politics, the stress of the defamation case. And then he settled out of court with Shanks, but kept Google. As I said, he should have settled with Google and kept going with Shanks if he thought. There is a rumour, not substantiated, that Shanks is going to be a witness for Google because it's based on his videos. I mean, that would make the most likely sense because Google has said that it looks like it was well researched and it was this and it was that. He's probably going to have to attest to that, how those videos were researched and who did what and how they were made. It does look like he's stopped fighting the same battle twice, yeah. If the case would stressed him so much he had to quit his job, case would good. Well, that's right. It's believed that he was at Christmas was with his new girlfriend and her family. So, So anyway, that's all I had for you at the moment. There is some other stuff going on because Clive Palmer, a millionaire, has sued the West Australian Premier for defamation. And WA has the strictest laws. Well, still has a closed border at the moment. Their border's closed at the moment. You can get out of the state. You can't get back into the state. But the federal court in Sydney have told the Premier of Western Australia, Mark McGowan, that he has to go to Sydney. So that is now going to he now has to fly to Sydney. So the question is he like everybody else that's currently left WA, can't get in? I mean, there are people that for example, broadcasted sport, have not been able to get back into the state. So that's an interesting one. So I'm just collating all the documentation for that matter because that is going to be very interesting. So that's due. Mark McGowan's due to face the federal court in Sydney in February, I think. Oh, it's February tomorrow. Late February, early March, I think. So we might look out. We'll have to pick up that case before it goes further. So that's another case to follow up, and we've still got. Well, that's the interesting thing. Is he going to open up the border so that he can get in and out, or is he going to have to stay in Sydney and run WA from Sydney? Because there are people, as I said, there are people who got work in WA that can't get into the state because they can't get in. There have been people like, for example, one of the doubles tennis players that played on Saturday night. His wife is due to give birth any day, and he thought the border was being opened on the 4th of February and he'd be able to get home for the birth of the baby. But now he can't get back in. He played in the Australian Open. So he's not very happy. So he's going to miss the birth of his baby. So, So there's lots of stuff. I mean, there's, you know, as I said, some of the cricket commentators have had to spend Christmas away from their families. So, you know, there are implications in all of that. But it'll be very interesting to see what Mark McGowan does with the border now. But anyway, on that note, I'm going to leave you all for now. I actually thought I was recording this. So I thought this was recorded. And anyway, so apparently I accidentally went live. But that's okay. My neighbour's daughter is a teacher in a very remote community who came to Vic for Chrissy and now can't get back. Yeah, and as I said, a lot of the people thought, that they could get back in and out, but they can't. So very interesting. Anyway, thank you for joining me. So on this saga with Bruz and Google. I don't know. Do you think Bruz has a chance? Is there a chance he's going to win? Imagine if he had to pay Google's lawyers' fees. That would be horrific. Those bills are going to be huge if he has to pay Google's fees. Yeah. So anyway, I will catch you later. There'll be some more videos. I've got to do some recording today. My first day home in 14 days. Yeah. So I'll be back. You would not want to pay for Google's lawyers. I would not want to pay for Google's lawyers. No, they've got one of the top the law firm in Australia is one of the top law firms, and is an international law firm. So they'd have lawyers working on this all over the world. So very, very interesting. All right. So thank you very much for joining us and joining me, and I will catch you again next time. I don't know when that will be. I'll try and give you a little bit more notice next time. Okay, bye for now.